oftentimes the ministry is calling us up and they're saying, hey, we just received a letter from an attorney. We're being sued right now. And I'm like, wait a second, hold on, tap the brakes just a minute. Not a lawsuit yet. It's a letter from an attorney. It's a demand letter, or it might be a letter from an angry parent at a school or whatever it is. But Bob, this is kind of the warning shot. This is kind of the precursor to a lawsuit. And that's usually when we call, we'll get the insurance company involved, we'll get the church's attorneys involved. If they don't have an attorney, we're usually calling BQB. And so that's why I've got you, Bob Brockman, here from BQB to kind of talk through this a little bit with me and kind of run through some of these different scenarios and what we can expect and what we should be doing in these.
Yeah, Charlie, I think you're correct. When I see a letter like that, it's usually the first step in the claim process, and the claim may go to litigation. It may not. I view it from the most conservative standpoint. We always hope for the best and hope that things will be resolved very quickly and very efficiently, but we are preparing for the worst case scenario. So when I get a letter like that, I view that as the first step in the litigation process, that a lawsuit will be coming shortly thereafter. So I take those very, very seriously. And the question is, how do we react to that? And how we react to it is very important. One of the first things that I always recommend to clients is do not pick up the phone and call that attorney, or do not call the client that attorney represents. The reason is this: attorneys are very artful and very skilled at talking with people, and everything that you say to that attorney could come back in a negative way later on if litigation is filed. It could come back as an admission that you made in the discussion. It could come back that you're acknowledging that the plaintiff was severely damaged in some way. All of the things that attorney is trying to prove against your ministry. So I would suggest that you don't call them, don't call their client. If you have already been working with BQB, certainly call us and let us know immediately, and we'll guide you through it. If you aren't working with BQB and you don't have an attorney, please call Church West, let them know about it right away. A couple of things are going to happen from the call, either to my office or to Church West, is we're going to look at whether or not there is potential insurance for the claim that is made in this letter. And the reason that we do that is an insurance policy is a contract, and that contract, if it potentially covers this claim, has a number of provisions in it that are important. And one of the provisions usually is that when a claim is made, or you expect a claim to be made, that you need to put the insurance company on notice of that claim. And I assume you do that all the time, right, Charlie?
Right, and that's a really important point. So does a ministry have to wait until they get served with a lawsuit that's been filed with the courts before they have a claim? What's your opinion on that?
Oh, absolutely not. They don't have to wait till a lawsuit is filed. If you've gotten a letter, someone is making a claim, you're on notice that this person's making a claim. And certainly if there's potential insurance coverage, as an attorney that represents the ministry, we want to make sure that if there's potential insurance available, that ministry avails itself of that benefit. So we would want to make sure the insurance company is aware of the claim. The insurance contract also has a number of other provisions in it that we need to keep in mind. If a claim is made, that the insurance company has the right to investigate the claim. So we want to turn it into them to allow them to begin their investigation.
Even without a lawsuit?
Even without a lawsuit, absolutely. Okay. Absolutely. And, and insurance companies are very sophisticated. They have seen many of these letters in the past. They know that a lawsuit may very well be coming. And in my experience in dealing with a variety of different insurance companies, they're going to start looking into it as soon as the claim is made. The insurance contract also provides a couple of things that are very important in this regard. First of all, it provides indemnity, which means that if the claim is covered by the insurance policy, that the policy will potentially pay for the damage that has occurred. But it also provides a defense. And the defense means that if a claim is made and the lawsuit is coming or has already come or comes shortly thereafter, that the insurance company will provide an attorney to defend the case. So all of these obligations under the insurance policy that the insurance company has, they don't begin, they're not triggered until the insurance company is put on notice of the claim.
Yeah.
So we want to let them know as quickly as possible. I feel a little bit out of line here, Charlie, because I'm talking about insurance policies generally, and I'm talking to the guy who's the expert in the area. So am I missing anything?
No, this is the tough part, is that it's confusing. You haven't received that. You just get kind of a nasty gram from an attorney. Like, let me give you one of the scenarios. I'm gonna put you on the spot here, Bob. This is frequent. You get an attorney. Let's say you've let somebody go or somebody quit, and then you get a letter from an attorney. They're an employment attorney, and they're asking for all kinds of records, employee files, and this, that, and the other thing. It's not coming from the courts. It hasn't been filed with the courts. It's a nasty letter from an attorney from a former employee. How should a ministry be handling something like that?
I would handle it in exactly the way we have just described, because that nasty letter from the attorney, if it's an employment matter, is going to tell them that they represent this your former employee, or even perhaps a current employee, with regard to any claims that they have, and they would like you to provide them with a copy of the personnel file and any payroll records and that type of thing. There are provisions in the labor code that identify what records they are entitled to get and in what time period they are entitled to get them, and what penalties you're potentially exposed to if you don't provide those timely. So when I get that kind of a letter, we definitely want to get the appropriate records sent to the attorney. But I view that letter as the very first step in an employment practices type of case.
I feel like they're trying to circumvent the normal claim process, where they're going directly to the ministry, and the attorney is trying to get more. They're trying to get more data, and they're trying to build their case before the insurance company or an attorney gets involved. So we want to be really aggressive at that point.
Sure. They are trying to gather what evidence they are legally entitled to receive as quickly as possible before litigation is filed, because once litigation is filed, then there's a time delay before they can start requesting documents from you. Right. And then they have to send you a request for documents, and there's time periods that allow you to respond that are longer and can be quite a bit longer. So this letter that you have described that demands documents under the labor code is their quickest way of getting information about what is in this former employee's records with the employer.
But I just want to warn everybody, that doesn't mean grab all the old employee files and start shredding them. You still need to search them. Don't do that. But don't hand them over right away. We want to get some guidance for you, as you're going through this process.
Sometimes these letters are way broader in their request than what the labor code entitles the employee or their attorney to. So we look at the letter and look at what documents are requested, and we provide those that they are legally entitled to get, as opposed to this, this wide bandwidth of things that they've requested.
Sure. Let me give you another scenario, and this happens a couple times each year. And I had this happen just a couple of weeks ago, and it was a kid that was bullying. I got really involved in the situation with this school, and the kid had every opportunity to get his act together, and the parents had every opportunity to, help get their kid to behave at school. And they finally just said, he's a problem. Enough is enough. We're kicking him out. They kicked him out of the school, and this would have been probably mid-April. And they didn't get a letter from an attorney, but they got a letter from a parent, and a parent was saying, hey, you kicked my kid out. You can't kick my kid out. I want all my money back, and this, that, the other thing. And they start and a school starts getting in the position where they're kind of almost negotiating with an angry parent. They're settling before the lawsuits happen because there's like threatened litigation. And so, what do you feel about a ministry kind of, going through a negotiation when there's a threat of litigation, whether it's a school or a church or something like that?
Yeah, you raise an interesting point, and it's a risky sort of a thing to deal with. You have to be very, very careful about it because, from my standpoint, somebody is making a claim, and there is a significant possibility that that a lawsuit is going to follow, and I'm looking to do the best I can in representing the ministry. And if there is potential insurance that covers that claim, I want to make sure that we comply with all steps in the insurance process. And one of the things that the insurance contracts you usually see, one of the provisions that they'll have in there says that the insurance company has the right to make settlement decisions. So we don't want to get into a position where we are taking steps that might be in conflict with the rights that the insurance company has under the policy. So we need to make sure that that we put the carrier on notice of the claim immediately. And if we are inclined to try to resolve it, and we think we have a good shot at that, at a minimum, at a bare minimum, we want to let the insurance company know this is what we are intending to do and see if they have an objection to that before we do it, because we don't want to breach our contractual obligations under the insurance contract to let them control settlement.
So it's something that the ministry can do outside of insurance, but it's a good idea to let their insurance company know that this is what they're doing.
To a point, yes, but we don't want to get to the point where we're negotiating some sort of a settlement. And then, I went through this process with a client recently where the client had actually negotiated a resolution with their now former employee. And then they came back to me later on and say, hey, we may have insurance that covers this. Should we submit it to the insurance company and see if they want to reimburse us for the amount that we spent to settle it? And I'm like, you've put the cart before the horse there. If you want the insurance company's protection, then we've got to follow the process that they have in place.
It's true. So, okay. Well, Bob, hey, thank you very much for the time. I think it's been great guidance. I think that ministries will find this helpful, and appreciate it. We'll talk soon.
Always happy to help, Charlie.